Welcome one and all to the international webinar on a practitioner's perspective on the international refugee crisis hosted by Diplotix. About Diplotix, we are an inclusive community dedicated to innovation and excellence in model political competitions. We desire to groom the leaders of tomorrow by providing a touch of political and diplomatic world to young students from school level to university level. Diplotic supports students and scholars from all over the world and contributes knowledge and expertise locally, nationally, and internationally. Such exposure would be directed towards developing and maintaining overall growth of political as well as diplomatic skills, which can facilitate peaceful resolution. I feel honored today to welcome our esteemed speaker for the session, Alexia Solomou. She is an international law expert currently serving as a caseworker at the European Asylum Support Office and as a faculty of UNICEF. She previously worked as an associate legal officer at the International Court of Justice, during which she received the award of Best Young Cypriot Lawyer Abroad 2018. She was previously research associate to Professor James R. Crawford Supreme Court at the University SC at the University of Cambridge, and before that research and publications assistant to the director of the Lauterpacht Centre for International Law. She is admitted to the Bar of England and Wales and Cyprus. She is the first female from the Republic of Cyprus to receive the diploma of the Hague Academy for International Law. She also holds an LL.M from Columbia Law School and an LL.B from French Law from University College London and University of Paris. Her main areas of expertise include international dispute resolution, asylum and refugee law, international human rights, international criminal law, land and maritime boundary delimitation, and the use of force in international law. Thank you so much for everyone. Thank you everyone for joining. Without any further ado, let us begin. I would like to request the speaker to take the session forward and enlighten us all. You can all ask the questions in the chat box. Ma'am, you're not audible. Your mic. Yeah.
Yeah.
Perfect.
Hello, everyone. Greetings from Cyprus. Thank you so much for the kind invitation to discuss this very, very important topic of international law. And without further ado, I'd just like to get cracking on the topic. I think this topic is of great significance because currently there are 80 million people who have fled their homes across the globe. So it's an issue that is affecting a very, very large part of the global population. Actually, the majority of the people who have been forced to flee their homes are children. So children are particularly vulnerable and are adversely affected by this issue. Furthermore, what is interesting is that half of this number, the 80 million people who have been forced to flee their homes are internally displaced people. And what does this mean? It actually means that these people, they have not managed to leave the borders of their own countries, but they have been forced to go from one region of their country to another region of their country. So that's why it's called internally displaced. Now, I'd like to start with a distinction. Being a lawyer and liking the categories, there's a bit of a, let's just say, misunderstanding between what an asylum seeker is and what a refugee is. And many times we call everybody who has fled their homes a refugee, and that is actually incorrect. And that's why I wanted to start from the definition. So an asylum seeker is somebody who their home and has gone to another country and has applied for asylum. So the determination for refugee status is actually pending. It has not been determined yet whether this person merits refugee status, merits subsidiary protection, or will be rejected in terms of their application for refugee status. So this is the applicant, the asylum seeker, and the other category is the category of refugee. And that's when actually your application as an asylum seeker is successful. I'm going to take you through the criteria of what constitutes a refugee, and this is a big chapter and mainly the topic of today's topic, but there's a distinction I want you to have clear in your minds, the distinction between an asylum seeker and a refugee. The one is the applicant, the other has actually received a yes to their application. And the third distinction is what I mentioned before with internally displaced people. Internally displaced people cannot actually apply for refugee status because the whole point of the International Convention on Refugees is a cross-border nature. You actually need to exit the boundaries of the frontier, let's say, of your state, and apply for protection in another state. And the issue of IDPs is more or less a legal black hole because the international protection for refugee law does not apply to IDPs, and so we have a bit of a gap in terms of the protection of IDPs. Many people, many scholars argue that the same protection should be granted, but actually, in order for such protection to be granted, a state needs to enact a legislation because it's a matter of domestic law. So the moment we cross a border, it becomes an issue of international law, whereas if it's within the state, it's an issue of domestic law. Now, states can implement a treaty that concerns domestic law, but that step needs to be taken, and it has not been taken yet. Now, this is the definitional issue I wanted to outline, and I want to give you a few examples of countries. The most applications for refugee law come from these countries. They're not exclusive to these countries, but this is where the majority of applications come from. It's mainly African states, so the Central African Republic, Sudan, the Democratic Republic of the Congo, Somalia, and recently number 2 is Afghanistan, and number 1 is Syria. Now, in my practice, the main cases I do is essentially Cameroon, and in particular the Anglophone region of Cameroon, because there's a secessionist movement there, and the operation of a paramilitary group called Ambazonians. And the other country I deal with a lot is the Democratic Republic of the Congo. And the third one in Africa is Nigeria. In Nigeria, I mostly deal with cases of that deal with the Fulani herdsmen, which is a herds group that operates in a very haphazard way and does attacks on civilians. Also, I deal because I'm located in Cyprus and we are north of Africa and to the west of literally the Middle East. Nowadays, we don't deal so much with Syrian cases or Palestinian, which used to be the case a lot in the past. But we deal with a lot of Iranian cases, and now there's an influx of Afghani cases, and it's quite interesting because some of my colleagues they have been called to support Lithuania out of all countries in Europe because apparently there's a big influx of Afghani asylum seekers from Afghanistan to Lithuania, so they have been called to support. So these are the introductory points I wanted to make, and now let's get to the main part of the discussion. Now, I'm sure many of you are familiar with it, but just to cover the basics, the main legal instrument that governs this area of the law is the 1951 Convention on the Status of Refugees, and its a subsequent protocol. In the European round, there's what is called the Qualification Directive. It was enacted in 2011, and it essentially takes the provisions of the International Convention and incorporates them into EU law. And in turn, the EU provisions are incorporated in the domestic legal systems of member states of the EU due to the doctrine of EU law of direct effect of actual EU directives. Now, if you will allow me, we're going to go to the definition of what is a refugee, and just for the sake of precision, I'm just gonna give you the actual definition, which states as follows: a refugee is a third country national who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group, is outside the country of nationality and is unable, or owing to such fear, is unwilling to avail himself or herself of the protection of that country, or a stateless person who, being outside of the country of former habitual residence of the same reasons as mentioned above, is unable, or owing to such fear, unwilling to return to it, and to whom Article 12 does not apply. Now, it's a long, complicated definition, and we shall break it down. So this is what a practitioner does when they see a definition, and that's the title of the presentation today. To me, when I conduct a legal analysis, I see three elements in this definition. One is persecution, two is fear, and three is the grounds upon which you're persecuted. And the grounds are the following: race, so essentially where you come from. And actually, race is quite interesting because, for example, in many, for example, African states, there's tribes. So usually in interviews we ask applicants, which tribe are you from? Not even what nationality are you, but which tribe, because race is very much linked to tribal characteristics. The second ground is religion, and religious claims are quite important, and mostly the religious claims I've dealt with come from Iran, and many Iranians flee their country because either they do not wish to follow Islam, or they become Christians. So this is what we call conversion claims. So they actually convert to a different religion, and actually in this case they convert to Christianity. The third is nationality, and nationality is very much interlinked with race, but nationality is the broader term. But nationality is the broader, let's say, concept. The most important ground, and this is what we call political refugees, is political opinion. So essentially, being persecuted on the basis of your political opinion. And what comes to mind is a case that I did from Cameroon, whereby an applicant, he was an active member of a secessionist domestic organization. He had a high ranking position within that organization. He organized the meetings and the publicity of that organization, and not only that, he very expressly expressed his political opinion that, you know, Cameroon, the Anglophone Cameroon, should become independent from Francophone Cameroon. And what I remember is he actually burnt a flag at a demonstration and got arrested and got tortured. And actually, because we have to double check the external credibility of what applicants state in their interviews, it was interesting because I actually did find external information reported in the press of the actual flag being burned at that particular demonstration. And so this is very briefly, political opinion is a big chapter. And the final one is membership of a particular social group. And this ground usually invoke it when it comes to some of the most difficult cases I've dealt with on human trafficking. And for example, as a woman, you can be a vulnerable member of women who have been trafficked, and that constitutes a particular social group within a society that can be marginalized and can be targeted upon return to the country of origin. Now, the way a practitioner proceeds in assessing such applications is after outlining the key elements of a case, to identify the material facts. And the material, they're called material because of their pertinence to the definition that I outline on who constitutes a refugee. So usually a material fact could be, for example, this particular applicant joined the Ambazonians in Cameroon and fought against the Francophones, for example. Or this particular applicant was trafficked by her husband to the Republic of Cyprus, and she was forced to have forced sexual relations with various men. So these are the kind of material facts that we identify in order to assess whether the definition is met. So when we are examining the material facts, we do a two-stage analysis: internal credibility and external credibility. So in the internal credibility, we actually check whether the account of an applicant is actually credible. So if, let's say, so there's 4 criteria: consistency, coherence, detail, and specificity. Okay, so if an applicant, we can discuss about this in the Q&A if you wish. If an applicant, let's say, says one thing to me and then I press him on a certain point and then changes their story, that's a red flag. Or, for example, I ask a specific applicant, they tell me a story about, let's say, the burning of the flag, what that we mentioned before, and they are unable to tell me where it took place, when it took place, who was there, how many policemen, whether it was reported to the police, whether after the beating this person went to the hospital. So if the account lacks detail and specificity, again, it's a red flag. So if it's incongruent, if it's inconsistent and doesn't have any detail, the internal credibility cannot be substantiated. Now, if it is substantiated, then we go to the external credibility. And what does that mean? It means that it's basically a cross-check. So we double-check whether what the applicant told us is indeed true by making a research in external resources, whether this information is accurate. Now, so for example, with public events like the one of the burning of the flag and the massive demonstrations, let's say, and the lockdowns in Cameroon, it's easier to find information. But for example, if let's say a woman has been sexually abused within her home by her own husband, there will not be a news report on that. The only thing you can find is reports on sexual violence or in that country or human trafficking in that country, but you will not be able to find very detailed information on acts that are of a private nature. And the same goes with torture. Many times we can establish the pattern of torture within a country, but we are unable to establish that this particular, let's say, policeman or this particular military person indeed tortured this particular person. So, and when we can't find that information, we tend to outline it in our reports and say, there is a pattern in this country, but the specific scenario has not been able to be cross-checked. And usually that's enough information to substantiate the external credibility. I'm happy to take further questions on this once we finish the presentation. So once we establish the material facts, their internal and external credibility, we go to the risk assessment. So what does this mean? It means whether the person being examined at hand, if returned to their country of origin, will face persecution. Is there a risk? That's the risk assessment. The risk should be specific and individual. It cannot be a broad risk. So if, for example, an applicant tells me, I fear that I will be killed when I go back home. Yes, but who will kill you? Why will they kill you? What is the individual risk that you specifically are facing? So, for example, in the situation of the high-ranking member of the secessionist organization, this is a high-profile person. They're looking for him. Sometimes these people are blacklisted, and many times they present to us arrest warrants that actually, indeed, the police is looking for them, and warrants have been issued. Arrest warrants have been issued against them, and the moment they step foot in their home countries, they will be arrested and they will be detained or arbitrarily arrested or even killed in the case of some people. Now, this is what I wanted to tell you about the risk. And in case the credibility fails and the risk fails, there's a catch-all category, call it like this, which is called subsidiary protection. So if you don't manage to meet the definition of a refugee because there's no fear, because there's no persecution, because you don't subsidiary protection. There's 3 grounds that you can be granted subsidiary protection in international law. And the first one is whether if returned to your country of origin, you will face the death penalty. So if a specific person has a case pending against them and the penalty on that is the death penalty, that person cannot be returned to their home country. The second category is torture or inhuman or degrading treatment. I'm going to turn to torture in a second because it's a big issue in international law in general. And the third one is serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict. What does this mean? It means that we cannot return a person back to a situation of armed conflict because there is a risk that they might lose their lives if they go back to a war zone, essentially. And how do we establish that? Normally it's recognized by the ICRC, by international humanitarian law organizations. ACLED, we use a database called ACLED that identifies the level of violence, indiscriminate violence in specific regions and in specific countries. So we use that database in order to substantiate what we call the Article 15C. Now, moving to the last part of my presentation and the most experiential one, really, I wanted to touch on 2 big issues in my view. The one is torture, and the other is trafficking of human beings. And the reason why I chose them is because they're the most difficult ones, the most challenging ones, and really many a time the most rewarding ones to work on as a lawyer who works in the humanitarian field. Now, the real challenge is not because the definition, let's say, of torture or THB is not set. It is set. It's in the Torture Convention, it's in the European Convention on Human Rights, it's in the Palermo Protocol for Human Trafficking. The legal definitions are there. What is really challenging, and this is where the practitioner perspective comes in, is that these are very disturbing experiences that human beings had to go through. So let's start from torture. One of the examples that I dealt with was an applicant, a male applicant from Africa, from Cameroon, who, in detention, while in detention, the people who had detained him cut his flesh, his arms, and he was showing me his arms like this, with the wounds, cuts, and he was electrocuted. Now, that is not a very easy memory to recall. So there's issues about memory. A lot of people black out. They can't remember it. Their memory goes fuzzy. Or they can't remember the details because actually the human brain shuts down certain information in order to survive. It's the survival mode of the human brain. Some things it shuts down so that it's able to continue its survival as a species. Two, the second issue is that because of this, because of the nature of these experiences, applicants, they face a lot of psychological troubles, a lot of psychological problems. So a lot of them suffer from depression. A lot of them suffer from post-traumatic stress disorder. So the moment they think of this traumatic experience, they lose it, they lose their grip. So many times I cannot continue with the interview, and I have to interrupt because it's so disturbing. Actually, recalling this kind of experiences, which is the worst humanity has to offer, really. So as I said, the difficulty is not of a technical nature, but it's of a psychological or memory nature. And to me, because of the way memory works and because of the way law works, and this is the real issue I want to touch upon today, is there's a bit of a mismatch because the law has these standards and the evidence has to meet these standards. And many a time, because of the nature of these events, sometimes applicants don't make sense or they forget things. So as I said before, the level of detail might not be there, or the specificity might not be there, or the coherence might not be there. You know, somebody told me, oh, I was tortured 5 times, and then they told me, oh, I was tortured 7 times. And when I asked them, but you told me 5 before. Oh yeah, but they tortured me again and again and I lost track. So if it's so traumatic, it becomes a bit of a jumble in your mind. But the law has to maintain that very high standard. So as practitioners, we have to respect the law and we have to apply it. But at the same time, as a human being, if I may talk as one, you understand why these people might not recall every single detail of how they have been tortured, or how many times they have been tortured, or on what day they have been tortured. Okay, so the other big issue for me, that's quite a few of my cases, is human trafficking. So human trafficking is a real issue, especially when it comes to women, and it is set out in the Palermo Protocol. And in Article 3, if I may outline it, trafficking means the recruitment, transportation, transfer, harboring, or receipt of persons by means of the threat or use of force or other forms of coercion, of abduction, of fraud, of deception, of the abuse of power, or of a position of vulnerability, or of the giving or receiving of payments or benefits to achieve the consent of a person having control over another person for the purpose of exploitation. Now, that's a long and complicated definition, but there's three elements to it: the act, the means, and the purpose. Okay, so the act is the transfer of a person from one country to the other. The means is the way they've been transferred, and the purpose is sexual exploitation. Now, one of the most difficult cases I've dealt with in my career was a human trafficking case. And apologies for the grim details, but these things need to be told by someone, I believe. It was a woman from Cameroon, and she was homosexual. She was a lesbian. Okay, and it was discovered that she is one. And in Cameroon, it is illegal to be homosexual, and so she was being threatened. People were harassing her to flee the country, and arranged to flee her country without her knowing was a trafficker, and she was trafficked to the Turkish Republic of Northern Cyprus, which is a non-recognized state in international law. And when she arrived, it was announced to her that they forced her to have sexual relationships with men. And this was the first time she was having such sexual relations with people, because she previously was with a woman in Cameroon. So as a result of the abuse, the applicant contracted HIV. And because of the HIV, she contracted cervical cancer as well. And while having all that, she fell pregnant as well. So we're talking about every single possible ground happening to this lady. So she in law we call her a vulnerable applicant. So I had to follow a special procedure in order to process her claim. Had to report the case to the police because of the human trafficking element, in order to investigate the claim on human trafficking. I had to follow up with medical reports because of the HIV and cancer, and of course, she was a single parent as well, due to the abuse that she had gone through. Now, the applicant, it was a very difficult interview. We had to make many breaks because she was breaking down in tears. And not only that, at a specific point, I had to interrupt the interview because the interpreter was crying. So I could not have a proper interpretation of the case. And when I asked the interpreter why she was crying, she said to me, because I actually went through cancer myself and I know what this medical treatment is all about. So I had the additional layer of difficulty of also having to handle the emotions of the applicant, but also the interpreter. And the issues that I mentioned about torture, the traumatic experiences, the way memory works, the psychological nature of the case, they are all applicable in this specific scenario. So with that point, I would like to conclude. And I'm aware that we have an hour, so I've pretty much used the first 40 minutes. So it would be, I guess, an opportune time, if the moderator allows me, to open the floor for questions.
Yes, ma'am. We have a lot of questions in the chat box. I'll just read out some for you. First question is, what is the impact of states refusing refugee settlements on the refugee population?
Yeah, that's a very good question, actually. So this is how the procedure works. Let's say the 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 case is decided, so you get a letter, and it can be one of two options. The first one, you get refugee status, so you stay in the country. So that's all good and nice. You get your papers done, you get your refugee status, and you can remain in the country. Usually states have a 4 to 5 year period. The second option is that you get a rejection letter. So basically your refugee status application is declined. So in that case, you have two options. The first is to appeal. And in Cyprus, we have set up what is called the International Protection Administrative Court. It's a special jurisdiction where you apply for an appeal. You have 30 days to apply, and then that tribunal decides on your case. Now, the tribunal can reverse the previous decision and say, no, you get refugee status, so you stay. But it can say, well, the rejection was correct, so you have to leave the country. You can further appeal, fine. But usually, when it's a rejection, the applicant has to leave the country and return to their country of origin. Now, this is where things, this is real life, really. A lot of applicants never return, and they decide to go underground, and they decide to live off the system and work in the black market, and have no health care and no education to their children and nothing, which is the really sad part of the situation, really. And some of them go to other countries. I mean, they just leave. That's it.
The next question is, what is UNHRC doing to help newly displaced Afghans and Afghan refugees who wish to return home?
Insofar as I know, the UNHCR is processing applications by Afghani refugees on the basis of the criteria that I set out in my presentation. I know, insofar as the European Asylum Support Office, insofar as Afghanis in Europe, there's been expedited procedures to handle the influx of the of Afghani Afghani asylum seekers, and that's why some of my colleagues have been called to other European states to provide assistance with the determination of such claims.
The next question is, after the Afghanistan incident, do the people of Afghanistan who move to another country would be termed as refugee?
Okay, so that's an interesting question. So it depends. I'm going to give you a lawyer's answer. It depends on the circumstances of each individual case. So first, you have to determine, as I mentioned before, refugee status. on the basis of one of the six criteria, and if none of them is substantiated, then you go to subsidiary protection. Now, in our field, this is what we call 15C. So if there is indiscriminate violence due to internal or international armed conflict, then it's impossible to return somebody to their home country. So 15C, in my view, would be applicable in the case of Afghanistan if an applicant does not meet one of the 6 grounds of the convention.
The next question is, what has US done vis-a-vis Syrian refugee?
I'm not familiar as a Cypriot working within the European context. I'm not practicing US refugee law, but insofar as I know, from my readings, is that Syrian applications for refugee status are being examined according to the ordinary procedures of the convention, according to the legal analysis that I set out in my presentation.
Article 33, subsection 1 of the 1951 Convention pertaining to the status of refugee give a security to the refugees to be protected by the countries where they went for shelter, but what about the countries who were not signatory to the convention and similar convention also? They mean that where the national laws prevail over the international laws.
I'm sorry, I didn't understand the question. Can you repeat?
Yeah. So, Article 33, subsection 1 of the 1951 Convention pertaining to the status of refugee gave a security to the refugees to be protected by the countries where they want shelter. But what about those countries who are not signatory to that convention or similar conventions?
Oh, non-signatories. Oh, I see. So if a country is not signatory to the treaty, it doesn't apply, and so it's impossible to get granted refugee status if a country has not actually incorporated the refugees status framework. Having said that, a state may choose to adopt other treaties that may have similar provisions, or they may have a domestic law that has provisions protecting asylum seekers and refugees. So at the end of the day, it depends on the domestic legal system of a specific state, but a state is sovereign. So, and in order for an international obligation to apply to it, it needs to consent to it and to sign and ratify a specific treaty making provision for a specific provision.
The next question is, don't you think that the right of non-refoulement without explicitly recognizing the right to get asylum is only a partial solution for this global refugee problem?
I'm gonna answer with a yes, and I'm gonna invite the person who asked this question to email me. I'm happy to give my email, by the way, to applicants, because it's a huge discussion, and definitely it's partial, and I do not want to touch on, because this is going to be a public lecture, I don't want to further discuss this publicly.
Okay. What is your opinion regarding the Syrian refugee deportation? It's again about Syria. There are a lot of questions about Syrian refugee crisis.
Yeah.
We have one question about what do you think about the Rohingya refugee in India?
I am not familiar very much with the Indian context, but what I would invite the person who um, made this question is, I used to work at the International Court of Justice, and there's a very, very important case um, uh, between Gambia and the Myanmar. And the Gambia filed a case for provisional measures against Myanmar for the Rohingya crisis. And this was on the basis of the grounds of genocide, but to me, this is very, very much interlinked with the migratory situation in the countries. And it's genocide is a level up. It's the trying to exterminate a people on the basis of their race, and the court will determine that issue. And genocide is very, very hard to prove because of the large scale of extermination that takes place, but also the dolus specialis, as we call it in international law. There has to be special intent to exterminate a race. So I think to me that's the most pertinent question in international law at the moment with regards to the Rohingya situation.
We have one last question. What are your views on Belarus government and its attitude towards refugees and using them against neighboring countries?
I disagree with it, in short.
Okay. That was the last question for this session. Thank you, Miss Alexia, for such a vibrant, interactive, and knowledgeable session. I would like to thank all the participants for joining us, and I would request everyone to fill up the feedback form before you leave in order to receive your e-certificates. Thank you, everyone, for joining. Before we conclude the session, Diplotix is hosting its first International Model United Nations from 4th to 6th February 2022. There are two committees, UNSC and UNGA. Spots are filling fast, so you can reserve your spot now. If you don't want to miss any updates from Diplotix, follow us on our social media handles and also join the WhatsApp group so that you can get updates. Stay healthy, stay safe. See you all soon.